Workers' compensation law factors into construction site injury cases more often than not. Most people can't appreciate that when you get injured on a construction job, typically, while you're working for somebody, it's really a twofold case. It's really a hybrid workers' compensation and personal injury case. And the way that it differs is the workers' compensation claim is with the employer's insurance company for medical treatment, medical benefits, disability, total or partial disability benefits over the course of one's life. It's very much an administrative process, at least in my opinion. It's very heavy litigation for the workers' compensation applicants' attorneys, and it's very heavily based in medicine. That is something that we don't handle. We're focusing on the personal injury side of that case, and if there is a construction site injury, the personal injury claim or case or litigation, however you want to call it, is really focused on that client's pain and suffering, because the economic portion of that claim gets handled through workers' comp. The Workers' Compensation Board approves a settlement for all their past medical bills and their future medical bills, if any. They are not adjudicating pain and suffering. That is limited to a third-party claim. That's when we get involved. In the construction injury world, for there to be a viable personal injury case on behalf of the victim against a third party, it must stem against a non-employer defendant, 99% of the time. If an employer is the sole reason you were hurt on the job, that is a strict workers' compensation case. There typically is no personal injury theory that will be actionable. In actuality, if you end up suing your employer or a third party based solely on your employer's negligence, that case can be thrown out typically by way of a motion for summary judgment, and you're causing problems. So for there to be a viable claim, when we're doing a consultation with our client, the caller calls us and they're telling us what's going on, and sometimes we have to say, Mr. Smith, Mrs. Smith, we're so sorry to be the bearer of bad news, but this is not a personal injury case. Your best option is going to be to file a claim with the employer. Why does that create a problem? Because most people are still employed with that employer. So it raises kind of an interesting situation upon the employee in making a decision on filing a claim against the employer and then wondering, well, what if they fire me because I filed a claim? Totally within their right to do so, obviously, right? Exercising your rights that are given to you by the law is protected. So then what happens is during my call with the client, I'll say, you're protected, you should do that, that's the law. You should definitely pursue a workers' compensation claim. And if they end up doing something, give us a call back and we can refer you to an employment litigation specialist, because that may give rise to a retaliation case.